Good afternoon, friends. This is C. Nitin Pathak calling. Uh, Today, I'm going to discuss about the live subject uh, on uh, deliberation on subject under Section 148 is the recent judgment, which is our landmark judgment in favor of revenue, which is regarding there was an issue going on for quashing of 148 notices, as there is a new era coming for reopening of assessment under section 147, 148, 149, 150, 151. The whole section has been revamped. And in the mean period 1st April 2021 to 30th June 21, there are a lot of notices were issued. And there were notices were issued and matter was with the court. The court has come to a conclusion in a different way. Okay. एक second. Shift contained. Okay. We are going to discuss. I am C. Nitin Pathak, founder president of ISACA chapter Ahmedabad. I can be contacted through nitinmpathak@gmail.com. I am supporting people to do a lot of courses on ISACA in my blog and in YouTube. There are a number of presentations available to you on different subjects. Today we are deliberating on the subject. Any question, any query which is left unsolved, you can call on me, you can mail me, you can WhatsApp me, and you'll be able to. We will be able to guide you. I am running ISACA chapters. There is going to be a CISA crash course which are going to be started soon on Zoom. Anyone wants to join ISACA chapter Ahmedabad, CISA sees some different courses are going on cybersecurity. We are ready to guide you there. Please, I am a founder president. There is Dr. Khushru, Manish Nayak, Bhavik Nagori, and Viral Jani is there on 17th June. It's on Khushru cybersecurity is there. We are going to have a panel discussion on how to guide people, guide students in getting ISACA course. We are going to discuss a Union of India versus Ashish Agrawal, which is reported into 138textmen.com at 64. We have explained you in we have explained you section 147 to 141 up to 151. New provision, present judgment, what is the stand taken by civility, and what is the effect of judgment. And we have explained you in this common parlance. So those who are not CA or those who have cases which is pending before that would be available. This whole presentation would be available with section, with judgment, with civility circular, with PPT would be available in blog, and also the YouTube presentation right now. What was the matter before Supreme Court on this case? The assessing officer has issued a representation, it issued a reassessment notice between 1/4/21 erstwhile provision up to 31st 140 by relying on explanation on 2021 dated 31st March 21 and notification dated 38 2021 dated 27th, and on the basis of that notices were issued, and the matter was before many high court on quashing of these notices, and on the basis of that revenue has filed an appeal and the judgment is as under the substituted provision. Under the substituted provision of Income Tax Act, Finance Act, no notice under Section 1 can be issued without following the procedure under Section 148A. There were notices were issued without following 148A. Along the side, with the notice under Section 1, the assessing officer is required to serve the order passed under Section 148A. There were reopening of assessment, but 148A procedure was not followed. And 140 is a new provision which is in the nature of considered precedent to issue of 147, 148. By way of 148, the procedure has now been streamlined and simplified. It provides that before issuing any notice under section 148, the assessing officer shall conduct an inquiry. One, if required, with regard to, if required, is need to take a permission of specified authority which is mentioned in the section with respect to information which suggests that income chargeable to tax has escaped the assessment. And on the basis of information, they will issue a notices to SSC, and SSC will be given SSC will be provided with an opportunity to be heard with this, and on the basis of his reply, as per not less than 7 days, the time period is provided, and on the basis of consider the reply if any response to the so-called notice referred to in clause B as above, and decide on the basis of material available and record the evidence, reply as and when this thing. SSC officer shall pass an order is under section 148E. The new provision is substituted by the Finance Act 2021, being a remedial and benevolent in nature and substituted with specific aim and object to protect the right of and interest of the as well as the same in the public. The respective High Court have rightly held that the benefit of new provision shall be available even in respect of proceeding relating to past assessment year provided in section 148 is on or after 142 any notice are issued. So the question was related to notices issued under section 148 from 1/4/2021 to 30th June 2021, and no procedure is followed as per section 148A. 148A says that notice should be issued to the SSC with the information. SSC's reply should be received. SSC's reply should be considered and order should be passed under 148A. The view taken, the Supreme Court says that the view taken by High Court has been truly accepted, and therefore the judgment are proposed to be modified. They said that this order is okay, but we are modifying. The modification are as under the respective impugned notice under section 1(8) to respective issues shall be deemed to have been issued under section 148A as substituted by financial and treated be considered as so-called notice under section 148A subclause B. The respective officer shall within 30 days from today provide to the SSC the information and material relied upon by them, and the SSC can reply within 2 weeks thereafter. The requirement thereafter the procedure uska jawab do fir order do, then only the one reopen can be done. The requirement of conducting an inquiry with prior approval specified under section 148A small a, that is they should take an approval has been dispensed of one time, which has been an unamended provision one till the date which this order is said. The order of High Court has been quashed. The present order would be applicable pan-India on all judgment and orders passed by different High Court on the issue under which similar notices are issued after 1/4/21 under the 148 are set aside and shall be governed by the present order, shall be modified to the aforesaid. According to this, because of this, there are around 9,000 orders would be quashed and this should be applied pan-India. The present order is passed under the constitution of article of 142, and it should to avoid any further appeal by revenue on very issue by challenging the similar judgment and orders. Now on the basis of this, so the crux of the matter of the whole law is like this. 147, there is an assessment or reassessment done. Reassessment किसका होता है? इनकम का होता है, डिडक्शन का होता है, अलाउंस का होता है और लॉस का होता है. These are either assessed or reassessed on the basis of information available with them. 148 has been replaced with 148A. 148A says that there should be one limitation of law. Limitation of law is 149. 149 में क्या बोलते हैं कि if within 3 years of the end of the assessment year, you can make it on the basis of information available to you. If it is beyond 3 years, and less than 10 years, the the order can be made only if asset is the asset worth is more than 50 lakh. 50 lakh में क्या information, either it is related to books of account or evidence or document. Evidence, document, or evidence, document and books of account, either of yourself or somebody else, on the basis of which your income is escaped, then it can be opened for more than 3 years but less than 10 years. तो 3 से 10 साल में 50 लाख से ऊपर है उसका ऊपर होगा। तो ये जो इंफॉर्मेशन है, आइदर लेस देन 3 years, 3 to 10 years, you will be given a notice that these are the information. SS's reply would be received. Before that, certain procedure for compliance of परमिशन लेनी पड़ेगी, इनके बेस से असेसमेंट नोटिस आएगी। ये नोटिस रीओपन करने के लिए प्री इश्यू ऑफ नोटिस, then assessment notice should be followed. This is the crux of the whole cases. Now we are coming, we are not here to explain 147 new procedure also explain. सर 151 में जो भी किसकी परमिशन लेनी है वो परमिशन लेनी पड़ेगी. Now what is left here is because of these court has the CBDT has issued a circular कि ये एकदम streamline कर देते. We want to make it a streamline. We don't want to be hanky panky. So those who have not applied for an appeal, but still they would be entitled for the benefit of this. Okay. The Supreme Court set aside the judgment of dated on 4th February, 4th May 2022 in case of Union India of Assis Agrawal, integrated by validity of issue of judgment. Assessment notices. Assessment during the period of 1st April to 30th June, within the period of this TOLA. So this section, these extended reassessment notice were issued by the assessor under the provision of this 140 herein after referred to as new law. The reassessment under the old law shall be deemed to be a SCN. जो 1/4/26 से जो भी है वो deemed to be considered as Sukos notice, and for that the AO will give you the information. You have a right to reply. All rights and defenses available under section 1 are rights available to AO, all defenses available to SSE. Okay. The implementation of the judgment is made it streamlined. Simply make a uniform this thing. Those who have preferred appeal or not preferred appeal will be taken care. The Honorable Supreme Court has upheld the views of High Court that the benefit of new law shall be made available. Honorable Supreme Court says that 149 का जो भी right है SSE और इसका भी available है. So to the crux of this assessment here 13, 14, 14, 15 and 15, fresh notice under section 140 of the Act can be issued in this case with the approval of the specific order only if they fall under section 149 1B as amended by Finance Act and reproduce in paragraph 1. The specified authority mentioned in 1 should be permission should be taken. 16, 17 as it is falling within less than 3 years, you can issue the notices. Cases of essay required to provide material notice though. However, it has been noticed that notice cannot be issued in 13, 14, 14, 15, 15, 15, 16 if it is less than 50 lakh. 50 lakh की information either in the books of account or document or evidence. If it is less than 50 lakh for the assessment year 13, 14, 14, 15, 15, 16, case cannot be reopened. But for that different circular would be issued. Even if it is pending, it will be squashed and it will be stopped. 14, 15, you can issue new notices. Procedure required followed by Supreme Court. If the procedure required for the followed by election, this would be considered as CN. I think 2 week पहले ये पूरी का पूरी procedure जो पहले 148A में है that you need to follow. 2 week का time दो, इसके बाद जवाब दो. CBD in view of this, I have covered this. 147 income जो भी है 3 चीजें order में होती है. आपका loss, income, recompute loss, depreciation allowance or any allowance which has been escaped and 148, 153 escape 148A को follow करने का. Now these are in detail. I'm not going into this. I've deliberated right now on this in a very short time. Everything is mostly covered. If anyone has a question, just email me. This write-up is also available on blog. I have also put in here uh, the Supreme Court judgment, CBDT order, plus our explanation to make you very easily understand this thing. Thank you very much. Thank you. Our case, I'm a ISACA member, so you can come and contact me on this. Thank you very much.